Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk a little bit about provisional waivers. Now, I've got several videos that I've done on provisional waivers. However, there's been a new development, a new positive development, believe it or not, and I want to discuss this with you. Now, first of all, let me just briefly recap what is a provisional waiver. So, generally, if you're married to a lawful permanent resident or U.S. citizen, and you're inside the United States, but you don't qualify to adjust in the U.S., meaning you have to eventually go back to the U.S. consulate, wherever and whatever country you were born in, and you then normally, because you've been here out of status for more than a year, you're then subject to the 10-year bar. And depending on the time, it's called the 3 to 10-year bar, but for most people, it's the 10-year bar. And most people don't want to leave the U.S. prior, to getting an approval of the waiver of the 10-year bar, so that they know they most likely will only have to leave for a few days and then be able to come back as a lawful permanent resident. So the ability to know that you actually have an approved waiver it's called a provisional waiver, and the whole waiver thing basically is, it's a legal brief, declarations, affidavits, all kinds of other stuff, which basically say, I know I can't come back for 10 years, but please, all this hardship my spouse is going to suffer, forget about it and let me back in. Okay, that's basically what it does. So essentially, the provisional waiver was only allowed for people who are not inadmissible on any other ground other than the 3 to 10-year bar, meaning that they've only been here and they're unlawfully present and there's no other ground. So generally, if they have crimes or fraud or deportation orders and so forth, they were not allowed to file the provisional waiver. Well, now there have been new regulations and policies which have been issued, which essentially state that if you have a deportation order and you file the permission to reenter, that's another petition. But if you file it, then once the permission to reenter course would be approved, you then qualify in which to file the provisional waiver. So this is a great development in that even if you have an expedited removal order before you came to the U.S., even if you have a prior deportation order because you didn't go to court, all of that, you're still allowed now to file the provisional waiver. So, of course, it all has to be done in the proper time period, in the proper sequence, and so forth. But unlike, most everything else, which is getting more difficult in which to process, this, for whatever reason, is allowed to go forward and become better for those people who are eligible. So if you have a situation where you're not sure if you can file the provisional waiver, and of course with today's day and age, you don't want to just be sitting doing nothing, because there's plenty of risk doing nothing these days. Give my office a call. I'll be happy to give you a free consultation, let you know what can be done, and we'll go forward from there. If you like the video, click like, subscribe, and we'll proceed from there. Thank you.